Oh, we've just got one more straggler. Good evening, everyone, and thank you very, very much for making it out on this wet Easter weekend evening to come and hear us talk about Brexit. But my goodness, the clock really is ticking now, isn't it? It really is a year to go. Theresa's touring the country and saying, might be worth it. So there's a considerable number of concerns, I'd say, that the country isn't ready, but let's all get ourselves ready because there's going to be an awful lot to think through in the next 365 days.
That's a long transition period.
Most accurate thing said this evening.
I think if we've learned anything in the 20 months or so since the referendum, it's that there are an awful lot of awfully complicated challenges facing the economy, the constitution, and indeed the society of a country that is on the verge of making a great leap. We've tried to reflect all sides of that debate in prospect with voices including Norman Lamont and Robert Toombs, but there's no doubt that I think the bulk of the prospect writers and readers have been more on the Remain side of things than the other side of things. But we're going to make sure that all sides are catered for tonight. And so what we thought we'd do, rather than just have a kind of Remain versus Leave ding-dong, is take this question seriously of is the country ready? So we've got different people here who know a great deal about different aspects. They'll talk for 5 to 7 minutes each about those aspects, and then of course we'll give all of you a chance to come in and ask us things and endeavour to enlighten you. So in no particular order, we are going to have Jolyon Maugham, who's a leading tax barrister, but also someone who's been very involved in the legal cases, the many legal cases there have now been about Brexit, its reversibility and its implications. So hopefully he can talk to us about those cases and some of the broader legal constitutional issues that are raised by Brexit. And then we've got Catherine Barnard, who's from the University of Cambridge, a professor of EU law, who we asked to talk in particular about the question that perhaps settled the referendum, immigration. Do we know how it's going to change? Is it going to change in a manageable way or not? We've got Ian Dunt, who's the editor of politics.co.uk, but I think I can probably introduce him more effectively by saying he's the author of Brexit, What the Hell Happens Next, a book that I suspect is selling pretty well today. And then finally we've got Shanker Singham, who's brand new at the Institute for Economic Affairs, who has described himself as a Brexiteer who was reluctantly in favour of Remain at the time of the election, at the referendum, because of the disruption that posed, but now really does believe there could be opportunities as well as threats. So we're really going to try and hear from all sides. So thanks very much for coming. That's enough from me, although we'll all be sticking around hopefully and having a chat and a drink at the end. But first of all, Jolyon, over to you.
So I'm sitting here and I'm bowing my head in penance, metaphorically speaking, of course, because I'm about to commit the Gove heresy. I'm about to address you on stuff that I actually am genuinely expert in. It'll be everything you wanted to know about Brexit litigation but were afraid to ask, probably because you thought you'd fall asleep. There are 5 cases, actually, so it'll be a little bit like counting sheep. So what I'm going to do is I'm going to kind of run through those 5 cases. I'm going to identify what seem to me to be the salient political points and the salient campaigning points, the salient legal points as well, and just talk to you a little bit about what each of those cases is likely to mean. So I'm going to begin with a case that's up in Edinburgh, and that case asks this question. Can Article 50 be unilaterally revoked by the United Kingdom, or do we need the consent of the other 27 member states? It's a question that's being posed by 7 Scottish politicians, MSPs, MEPs and MPs, who say they want to know the answer because it will affect how they vote when they're either giving a legislative consent motion, or they're voting on the deal in the European Parliament, or they're voting on the Dominic Grieve clause in the withdrawal bill. And if you think, as David Davis once did, that democracy doesn't freeze at any moment in time, then you do want to continue to listen to what the people want. So the case is kind of interesting legally, and it's important legally because there are already rumblings that should the United Kingdom come to want to change its mind, there might be a price to be paid. It might be that some of the opt-outs that the United Kingdom's managed to negotiate in the past would disappear as the price for staying. And that's a fairly unpalatable prospect if you like those opt-outs. It's certainly a politically unpalatable prospect if you're trying to sell that deal to the public. So it has those important legal consequences. It's also quite important in campaigning terms because what it would do, if there was a reference to the Court of Justice, is it would put that question of remaining, the possibility of revoking, on the front pages for a period of time. And one of the things that we will all have noticed if we're keen observers of this is that the government has a complete stranglehold on the language, a complete stranglehold on the language of Brexit. So the Labour Party won't use the R word, the government won't use the R word, and we don't find it anywhere. We look and we look and we look, and it's not there. And so if you're thinking about this in sort of psychological terms, then you need to break that stranglehold. So it's got reasonable prospects, I think, of getting a reference. But judges are really, really frightened of this stuff because it's so politically toxic, and so their every fibre cries out against it. But it may nevertheless get a reference because fundamentally, legally, positively, it's right. It should be referred. So it's sort of a battle between those two judicial instincts. So that's the first case. The second case is another case of mine. It's the case about vote leave over spending. And so we launched a judicial review in October. By we, I mean the Good Law Project, which I founded. And the Electoral Commission said, don't be silly, there's nothing wrong with our investigation at all. We're not going to open another one. And then the day before they had to file their pleadings, they opened another one. And so that investigation is ongoing, and it's looking at whether Veterans for Britain and Vote Leave and Believe, Darren Grimes' organisation, were spending in concert. In other words, whether those nominally separate pools of money were really only one pool of money and being spent to the same end. So that's the question that the Electoral Commission is currently investigating, and in respect of which light might be thought to have been cast by revelations last weekend. But there's another question as well, a slightly sort of geeky lawyer's question, which is whether one campaigning group can donate to another campaigning group, and that donation not count as its own spending. And so the conventional wisdom, the kind of received wisdom, has always been that you can donate to another campaign and that not count as your expenditure. And I think that's wrong. And last week we managed to persuade the Divisional Court that it might well be wrong, and we'll have a hearing on that in June or possibly in early July. So that case legally does two things. It asks a question about the conduct of the referendum, but it also creates some important law about what spending might take place in subsequent general elections, or indeed how monies might be spent were there to be another referendum on Brexit. But the reason that it's so politically hot is this. The will of the people is a thing of great importance, great political political importance. And if you can undermine the will of the people, if you can say that the will of the people was unfairly obtained, then MPs might discover that they are able to do what many of them instinctively think is right, which is to say, actually, that referendum didn't really deliver a result that we feel comfortable in relying on. And so that's why there's all this enormous political heat around what's fundamentally a rather geeky point of election law. It just might give MPs permission to do what their instinct is to do. I'll take the next three cases relatively quickly. There's a case in Amsterdam that asserts, again, I'm afraid another one of mine, it asserts that all of us who are UK citizens and not citizens of another member state have an entitlement to retain our EU citizenship rights after Brexit, not as a matter of political gift, not, in other words, that they might form part of the withdrawal agreement, but as a matter of legal entitlement. So Article 20 of the Maastricht Treaty says that EU citizenship is separate from national citizenship. And if it's separate from national citizenship, that must have the consequence that it does not automatically disappear if national citizenship disappears. So we managed to persuade a judge called Judge Barkels in the District Court in Amsterdam that argument had merit, and he referred it off to the Court of Justice. And he's quite an interesting judge to persuade, because for many, many years he was the Vice President of the Supreme Court in the Netherlands. So he's not a small figure, very, very important judge, and he was persuaded the case had merit. So the Dutch government appealed. Their appeal is going to be heard on the 19th of April. But if that case succeeds, I think it would be no exaggeration to call it the most important legal case of modern times. No exaggeration to say that. But seriously, it would give a massive extension of rights to 60 million people. And I bet, he said bravely, that there's no one in the room who can think of another piece of litigation that's done that.
Can I just ask on that, do we know what the attitude is from the other countries and the other side, if you like, the Barnards and so on? Would they quite like this? Because suddenly we could all be saying, oh, we'll quite like to hang on to our EU passport.
They don't like it. And they don't like it for quite an interesting reason. The reason they don't like it is because fundamentally it asserts that those of us here who are UK citizens have an EU law right to retain our EU citizenship. But there is no reciprocal legal right. So an EU citizen cannot assert an EU law right in the United Kingdom after Brexit. I mean, that's, for some of us at least, the point of Brexit, that EU law ceases to apply. And if you really think about that for a second, and you recognise that this notion of reciprocity runs through all of the negotiations between the member states, what you see is that there is a political opportunity for the 27 to demand reciprocity to this legal entitlement that UK citizens might be able to assert, but they can only grasp that political opportunity if they find out early enough, i.e. before the withdrawal agreement's concluded, that UK citizens have the legal right to retain their EU citizenship. So the case has the potential to throw really quite a major spanner in the political works. And I think that's probably another reason why they hate it. And of course, if you're me, it's another reason why you like it.
Two more?
And then there are two more. One or two people nodding off. So there's a case called nominally the Article 50 case. And that case asserts that no decision to leave the EU was ever made. So the Miller case, which we all remember, said that there had to be a decision, it had to be made by Parliament. And the withdrawal bill asserts, well, it gives Theresa May the ability to notify a decision, but it does not actually constitute the decision. And I wrote about this on the day the bill was published. And then I began to wonder to myself, because this is the more interesting question, why did government do it that way? They could just have said, we hereby enact that we're leaving the EU, and then this point would not have arisen. And I think I know the answer to that question. I think that government knew that if Parliament enacted our departure from the EU, the foundation of our departure from the EU would be a decision of Parliament. And being a decision of Parliament, it would be a decision that Parliament could reverse. It would not be something that the people had done. It would be something that Parliament had done, and so Parliament itself could undo. And so I think there was a very important, and really, if you're me and you're really interested in the interplay between law and politics, a really, really fascinating piece of thinking that lay at the heart of what is, for a lawyer, a deliberate error at the heart of that bill. Now, this case asserts that no decision to leave the EU has yet been made, and we're all sort of running down this road to nowhere. And the case has got politely modest prospects of succeeding, not least because they took much too long to launch the claim. And then the only other, the fifth case is a case that was launched just a couple of weeks ago. Back in the olden days, when the Brexiters were not the establishment, they managed to persuade the Conservative Party to put in place something called a referendum lock. So before any more powers were handed to Brussels, as we call the EU, there had to be a referendum on that handover. And the funny thing is about a transitional period is that we will become a vassal state. So we will hand over, for a period of time, powers to Brussels. And so the case asserts... it sounds fun at the moment. I'm going to kind of quash that fun in a second. The case asserts that the referendum lock in the European Union 2011 Act requires that there be a referendum on whether or not we can enter into a transitional period. And legally, it's really quite powerful and compelling. The reason why it's not as much fun as I've made it sound, there's fun, of course, and there's lawyers' fun. The reason why it's not quite as fun as I've made it sound is this. One of the things that the repeal bill is doing is it is repealing the 2011 Act. And so Andrew Adonis and his pals are fighting a rearguard action to try and remove the provision in the repeal bill that repeals the referendum lock. But the government is determined, unsurprisingly, to ditch the referendum lock. Anyway, so if the government succeeds, then that case disappears.
Quandary on how to vote, though, isn't it? If you're a Remainer and then do you want the transition agreement or not? Because it wouldn't stop Brexit, would it?
Well, it would have the effect of forcing a referendum. So really, at the heart of all of these cases lies not an analysis of what these cases do in law. At the heart of all of these cases lies political considerations. These cases, if they're well understood, are vehicles to launch political arguments, to throw political hand grenades, and they're dressed up in legal clothing, but fundamentally they are asserting political, or fundamentally their effect sits mainly in the political sphere. Government is desperate to, two very short last points, government is desperate to not do anything which might look like supplanting the referendum result in June 2016. So it could not have a referendum on whether we entered into a transitional period because that might deliver a result that overtook the result of June 2016. And for the same reason, government, as I understand it, is insisting that there be no European Parliament elections in the UK in the transitional period, because again it fears that those parliamentary elections would turn into a proxy referendum.
Thank you very much indeed, Jolyon. That was a terrific tour around, an expert tour, dare we say, around all of those cases. I think, having just thought about the balance of the conversation, it might be good, Catherine, it's right with you to do Ian next. You can do a bit more raw politics, and then we come on to your talk, which would be more legal again. So,
I will be the meat and the legal sandwich.
yeah, I mean, one thing I was hoping Ian might say something about is, and he's written a lot of forensic stuff about this, is, how far is the civil service and how far is the government, if you like, ready for the challenges ahead?
Yeah, well, I mean, none of us are really, and as a country, we're not very prepared at all. And I think at the heart of that, there's basically three contradictions. There are many more contradictions than that in Brexit, but I'm just going to deal with three of them right here. The first one is really a sort of a time capacity problem, and that is core to the Brexit issue that we face. We triggered Article 50. Article 50 takes 2 years. Then the status quo position under Article 50 is you fall out without a deal. Now, that is not a very good status quo to be in. It's not a very good status quo because, of course, if you don't have the infrastructure for the customs arrangements, there'd be chaos because of all the trade effects. But much more importantly, it's not a very good status quo to fall onto because of what happens with your regulators. So we, at the moment, come under, for instance, a European regulator, Euratom, for nuclear materials, and for the ability to import those nuclear materials from the continent. Lots of the radioactive isotopes that we use in cancer screening and treatment have very short half-lives of about 66 hours. It's not really very convenient to get them from further afield because that thing is just degrading the whole time that it's on the plane if you take it from, say, Russia or from South Africa, where some of our other radioactive isotopes come from. So we try to bring them through the Channel Tunnel at night where there's no movement there. Now we lose the legal ability, the regulatory ability to import those materials if we're out of that regulator without having put something in place. The same goes for, if you take, and this is just two examples, if you take aviation. Aviation is done by a series of bilateral treaties. It's actually quite sort of almost primitive the way that it works globally, and it's been around since the Chicago Convention just after the war. In Europe, we have a rather different arrangement, which is that we have an incredibly open aviation system, where basically you're allowed to fly not just between your territory and another territory with a stop on the way, which is typically how bilateral aviation treaties work. But you're allowed to fly, if you're owned by a European company, from any one point in Europe to any other point in Europe without having any necessary contact with the home country, for instance, between cities in France. That is done by treaty, that is done through our relationship with the EU, for instance, through our membership of the agency EASA, which is the European Aviation Safety Authority. Now that, take EASA, we'll look at everything on a plane, the little trolley that you see as it's moving up and down, as well as the stuff in the engine, and vouch that that stuff is safe. If you're out of that regulator, it's very hard to stay in that system unless you've got something to cover you, to tide you over. That rather chaotic scenario made it highly unwise for the government to trigger Article 50 before it was ready, and even more unwise to trigger Article 50 and then decide in the middle of nowhere that we're going to have a general election for no particular reason at all. And then, of course, to go ahead and lose the general election was also extremely unwise. When you do most trade talks, the average trade talk takes about, we take Canada. Canada's a goods-only deal, so more simple than the one that we want to do. That took 5 years to negotiate. It took another 2 years to ratify. That's 7 years in total. Now, not all trade deals take that long. You look at, for instance, when America, I think, left after doing NAFTA. Usually when there's an overmighty trade partner, and it'll go up to the smaller partner and just put the basic framework of the existing trade arrangements it has and just goes, look, you can make 100 changes. You have 100 quibbles, but this is basically what you're signing. Now, it is not impossible that is a scenario that we will find ourselves with in Europe. And in fact, I think that's rather the direction of travel right now. But most of the time, trade deals take a long time to organise. Building up regulatory capacity to handle nuclear materials takes a long time to organise. Trying to work out the arrangements of how you do your own domestic aviation systems, if indeed you're not going to partake in the European ones, takes an awful long time to organise. If you want to build the kind of customs infrastructure that we're envisaging, that's going to take an awful long time to organise as well. We have a massive time capacity problem. And that is the reason that we are doing the transition period. That is the reason that Theresa May has buckled on every single fight that she thought she would have, whether it was sending money to Brussels, whether it was going to be under the ECJ jurisdiction, whether it was, as she inanely said at the beginning of this year, that she was going to get rid of freedom of movement during the transition. Every time she makes the promise and then she capitulates. The reason she capitulates is because the status quo under Article 50 without a deal is so appalling. Only 1 year to go, by the way. Fun times. That is one of our main problems. A second contradiction that we find is, let me remind myself what on earth it is. Oh yes, the Irish problem. The Irish problem is essentially this, that according to our own standards by going into negotiations, and according to what the EU has also committed to by going into negotiations, there must be no friction at the border. That is, no infrastructure at all on the Irish border. None at all. It's not enough to say that there's a checkpoint. It's not enough to say that there's just one guard. It's not even enough to say that there's just one piece of CCTV using highly advanced technology to scan license plates. No infrastructure at all. Now, the problem with that is that if you leave the customs union, the single market, there will be infrastructure on the border. And that is the decision that we have decided to make. Now, there are a series of propositions that are put forward sometimes by the government. In fact, some of the most interesting work, and by far the best work on this, has been done by an EU agency itself called Border 2.0, which is about as good a go at this thing as you could possibly sort of aim for. And it basically says, look, let's take every idea we have about how to make an open border function and just throw it at this thing and see if we can come up with some kind of new system. Now, it's very interesting. It's good work. It's smart work. Most of it's about trying to deal with space and time, which sounds like a big task. It is ultimately about if you can try to make people file ahead of getting to a border, their customs declarations. If you can try and get them to claim the money back after they've gone through the border, in the same way that if you're sort of self-employed, you might be used to doing with your tax returns. Maybe you can get rid of some of the friction on the border. There's a few more bits. You can add some tech towards it, but ultimately that's the idea. It then means that you can spread out the checks. If you look at the Norway-Sweden border, there's a 15-mile zone on either side where you can do checks on each other's territory, actually. So you could do it away from the border, keep that activity away from that sort of line. And the other part of that is that you would try and do tests in each other's factories via mutual recognition agreements, which are basically sort of statements of trust to say that you know that the other side are doing things up to your standard, they can do the checks for you, and you'll take their word for it. Now, all of this stuff is pretty sensible. The trouble is that you still have a series of very, very practical concerns with it. For instance, how do you differentiate between the kind of goods that are going up to that border? Mainly the Brexit ideas rely on the idea that we have, for companies under the sort of employees of around 250, but small to medium-sized companies, basically, that we take them out of the system altogether. How do you know? A lorry that comes from a company that has 250 employees looks exactly the same as a company that has 251 employees. In order to designate which are going there, you have to have some kind of infrastructure at the border. How do you know that the one that goes through that has to go through an agricultural point, and under EU rules you do need checks for agricultural products, for animals, for livestock and for meat products? How do you know that that isn't the first one there? So then therefore there is a tailback that comes from after it. And if we do start giving all these rights to small traders to completely evade the system, how do we control the kind of black market activity that we would expect to see when there's differences in customs rates? These are very real problems. They all necessitate the use of some kind of border. According to our own criteria and that of the EU, there can be no border. The end result of that problem, that unfixable problem, that contradiction, will be, I think, one of the defining moments of Brexit. And it will probably happen sometime in the next 6 months. In fact, it kind of has to happen sometime in the next 6 months. The final part was, what on earth was it? Oh, yes, so the contradiction within political parties. If you look, especially, I mean, it's there in the Tories. I mean, we're seeing actually something quite philosophical in the Tory party, currently sort of kept, which is really the difference between sort of patriarchal, nativist, authoritarians, kind of Shire Tories, and the more kind of George Osborne-y, global, multinational, let the capital fly wherever it wants Tories. Now that relationship's got a lot of friction, and actually a lot more than can be visibly seen. And if I think a lot of Conservatives thought that there was a viable Labour Party that didn't make them sick to their stomachs, I think that we would see an awful lot more moderate Tory action, and still may do, if they think that there is a genuine Labour Party that would vote against the motion when it finally goes back to Parliament. But by far the most interesting and probably, I think the most compelling split is within Labour itself. Between a leadership that has signed up to an awful lot of mostly myths, there's a couple of true bits in there, but with all political myths, there's usually a couple of kernels of truth in there somewhere that kind of give rise to the weeds. On sort of Lexit myths of the idea that the EU is some kind of great corporate, sort of neoliberal monstrosity, strangling the life from the working class. And the vast majority of Labour's voters, and especially its members and its MPs. Now, we've seen that this week in a very major way. We saw it at an extraordinary basis to have Gardner, first of all, and then Emily Thornberry say that Labour would vote with the government. This extraordinary spectacle. Because its 6 tests would be passed by a government that said blah, blah, blah. This is a direct quote. She was then shot down by John McDonnell this morning, who said that she was speaking sarcastically. Well, she may, I mean, baffling. It's clear, I think, that there's an internal war in Labour as to how they're going to vote when it comes to it. My hunch is if Jeremy Corbyn had his way, for a start, he wouldn't ever talk about the EU again, because my hunch is not so much that he's ideological, but he's just so bored by the entire subject and just wishes it would go away. But then politically, I suspect that what the Labour leadership really wants is just for Brexit to be done and over and not their fault. And once it happens, the left and the Liberals and everyone can just come together because they've all fundamentally got the same values. That great big sort of split over Brexit's happened. They know it will be a catastrophe, so they can hoover up some of the discontent as a basis of that. Sort of Tories, the Tory Brexit, that's what did it, and off they go. However, they can't do that because there's going to be a vote on the motion in Parliament that sums up the withdrawal bill that is arranged in Brussels. Now, the commitment is that will happen before the European Parliament, not the primary legislation. The primary legislation will come later. It may even come after Brexit. But the motion in Parliament about whether it accepts the withdrawal treaty signed with the Europeans, or that would be signed if they accepted it, will come in the autumn. Maybe October, probably November. Certainly by December. Now, at that point, that's when we really find out what's going on. And I think the key moment, something terribly important happened this week, I'll finish with this, is that Keir Starmer, who has not had the greatest time all the time, I have to say. I mean, watching him on Sunday say that passports needed to be made in Britain was enough to make me want to crawl back to bed until the end of my life. But nevertheless, he does have his moments. He mostly does have his moments. He's mostly good. He's mostly sound. And you can see him trying hard and getting it. And in this, he did something clever. He's trying to do something clever, which is an amendment to the withdrawal bill. The withdrawal bill separate to the withdrawal treaty. The withdrawal bill is the great repeal bill stuff that's sort of going through the comments at the moment, replicating EU law so that there's continuity of legal status. He wants to put an amendment in that would essentially give Parliament control of what happens if the motion is rejected. Now that's very important because at the moment what the government wants to say is that if you vote against the motion, you're voting for a no-deal Brexit. Now that is not the case. No-deal Brexit, for the reasons I outlined at the beginning, is catastrophic. The option between that and any deal is that you will take the deal. It is the same, I wrote the other day, as the option between being made to watch a film that you don't enjoy or being shot in the face. You're going to watch the film, but it doesn't mean that you like the film. That is not a meaningful vote under any criteria. On that basis, it is very intelligent for Keir Starmer to start doing that, and you can see him as one of those figures in Labour working out where the ball is going to be, not where it is right now, where the ball is going to be, where those fights are coming, where the sensitive areas are coming. And that is a reflection of the internal Labour battle, of the internal Labour contradiction on this issue.
And do you not think that the sheer temptation of any opposition to find a way of voting against the government, of course they're going to look a bit ambiguous, but in the end, John Smith teamed up with Teddy Taylor and all kinds of anti-European Tories in order to have a go at Major and Magistrate. This lot will do the same way.
But you're talking about a moment when politics was still sane. And that's no longer really the case. So I think that's got to be true that their instinct has got to be that way. However, there's, in some cases, real concerns in the leadership over how does that come across to the 1/3 of Labour voters and many more Labour constituencies, even though it wasn't necessarily their voters or members, who said that they wanted to leave the EU. They are concerned about the way they appear on press. But most importantly, it's not that. It is that the Labour leadership is ideological. It is the things that it always sold itself as being. And one of its ideological points is that it doesn't believe in the EU and it thinks it's some kind of capitalist plot. I still, by the way, if I had to put money on it, I would still say that overall, Labour's probably going to vote against the motion. But you can definitely see the moving around in there and that war taking place right now.
Thanks very much. Now, Catherine, as I say, the issue of the referendum was, the biggest issue was immigration. So with a year to go, do you think there's a plan?
No. There is no plan going forward because they can't decide over something really fundamental. And the fundamental thing is whether EU citizens should be given preferential access to the UK labour market as compared to non-EU citizens. In other words, should EU citizens be treated in just the same way as an Indian or a Pakistani citizen is treated now, or whether they get some sort of preferred access. Now, you're certainly right that immigration was probably the main reason why people voted to leave the European Union. And you should bear in mind context. And there were two important contextual issues. The first one was that in the run-up to the referendum, you've got the highest levels of immigration into our country ever. Secondly, you've got the migrant crisis taking place in the Mediterranean, which had actually almost no effect on migration into the UK because we weren't in Schengen, so there wasn't movement of the migrants from Hungary and the southern edge of Europe. But nevertheless, because some people were less scrupulous than others in explaining what's meant by migration, it was all thrown into the pot as migration, and all thrown into the pot marked essentially migration is bad and must be stopped. So that was the first contextual issue. The second contextual issue was that quite dramatic rise in migration to the UK coincided with the end of or extended period of austerity measures. And so, for example, local council funding had been cut in the region of about 40%, which of course had a direct impact on the provision of public services. And so, quite understandably, in people's minds, in areas like Spalding, in Lincolnshire and Boston and other places where I've done quite a lot of work on the ground, what you see is people putting two and two together. The reason why I can't get an appointment in the doctors, why I can't get my kid into school, is because of all of those migrants. And so there was a very bad system of timing, set of timing, which led to this. I'm not an economist, but my colleague Jonathan Portes is, and he writes some very fine papers on why the myths around migration. And I will just give you briefly some of the headlines. So the first point is the classic that migrants take our jobs. There is no evidence of that whatsoever. Contrary to common sense, the lump of labour fallacy, and I'm conscious that I'm trespassing in areas that economists can talk far better about than lawyers can, but the lump of labour fallacy, which sees the labour market as a cake, and every bit of the cake that you get, I lose and my family loses, is just not correct. And the evidence shows it's not correct in the medium to long term. It's also not correct in the short term. In fact, migration, because of the demands for goods and services, has the effect of expanding that cake. Second fallacy, that having high levels of migration drive down wages. There is very little evidence that this is the case. There is perhaps some evidence in the lowest skilled sector, and possibly the pressure on wages is about 1%. Thirdly, migrants come here for benefits. All of the research that I and others have done have shown this is just not true. Partly because they come to work, and secondly, they also don't understand our benefits system. It's very difficult to fill out the paperwork, particularly if you don't have English as a mother tongue. The only exception to that is in-work benefits, which you can get if you are low-waged and have a family. But even there, you've still got to fill out bits of paper and people aren't claiming. Fourthly, I think I'm up to 4, the argument is that migrants are very poor for productivity. All of the economic evidence, certainly which my colleague has done the work on, suggests that this is not the case at all. Just put it very simply, it probably increases productivity because it enables, for example, highly educated nationals or residents, women particularly, to go out to work because there is affordable childcare provided by immigration to actually facilitate that. So there is a very concrete way why perhaps immigration is good, improves productivity. There is finally no direct evidence on the effect of migration on public services. What there is a problem of is that there's been a very poor allocation mechanism of tax receipts to fund public services, particularly in areas like Spalding, which are less attractive for young, thrusting teachers, doctors to go and live in. Now, I say all of this to say that there is a very positive case to be made about immigration, which successive political parties have totally failed to make. What is, however, clear is even though the economics, the evidence does not support the negative narrative about immigration, it's very profound in the national psyche. And furthermore, the one issue which comes out time and time again is about identity. That in fact, even if people were convinced by the economic evidence to say that immigration is a good thing for the country and it raises GDP and does all sorts of other virtuous things, the fact is towns like Spalding say we have lost our local identity. People in the street don't talk English, and that's quite a difficult one to combat. So the reality is that immigration was possibly the main reason why people voted to leave. The polling evidence, however, shows that there's been a quite dramatic change in attitude towards immigration. People have become much warmer towards immigration, possibly because they are beginning to see that the NHS is really reliant on foreign nurses. And indeed, one of the causes, not the only cause for the crisis in the NHS this winter, has been a chronic shortage of EEA nurses. So the public have become more persuaded, but the narrative still is, well, what we don't want is the low-skilled. The low-skilled we don't want, the high-skilled we're very happy with. Now, this term low-skilled is extremely loaded and is probably incorrect, because the way Migration Watch and others use the language of low-skilled is people who are earning less than $35,000 a year. Now, if you think about that as an income threshold, $35,000 a year, in fact, it catches what we would probably in this room think of as middle to higher skilled, so it covers doctors and nurses, speech therapists, lab technicians, administrators, and so forth. Indeed, 3/4 of the British nationals would count as low skilled if you take that as a threshold. So low skilled is a very misleading term. There's a further problem, and the further problem is that this language of low skilled is used as part of what's called the process for assessing Tier 2 visas. So Tier 2 visas are for those non-EU nationals who want to come and live and work in the UK. The Tier 2 visa process is a complete nightmare. It's a nightmare, I know, because I have to administer it in my own college. I say grandly, I have staff to do it, but I have to oversee it. It is intensely bureaucratic, and it's also incredibly costly. And there is a cap on the number of Tier 2 visas which are issued each year. They're done on a monthly allocated basis, and for the last 3 months the cap has been hit. And indeed, the government has now moved the income threshold up from 30,000 to 60,000 in order to be able to get a Tier 2 visa. What you can see from this is that if the decision is taken in the post-Brexit world to treat EEA nationals in the same way as non-EU nationals are treated now, and thus needing a Tier 2 visa to get in, then whole swathes of the sector of industry will not be able to get the staff that they need. And so it will affect the NHS, unless you can argue that nurses are much in demand, so you cut the salary threshold. But the trouble is it requires a very nimble system for recognising what skills are needed. And by definition, the assessment of the skills is retrospective. It's the skills that were needed last year rather than the skills that are being needed for next year. So
we should just try and wrap up, because
yeah. So I would just say, therefore, the point is that there is a big decision for the government to take about what it's going to do about migration going forward. Are we going to go down the Tier 2 route, or will there be a preferential treatment for EU nationals? And if so, how rigorous will it be? Will it look more like the Tier 2 system, with a very bureaucratic system being applied by, for example, abattoirs who are totally reliant on EU nationals to do their veterinary work? Or Or should it be a much lighter touch system based on a work permit authorisation, which employers will do? My final point. The regular mantra is we need to take back control of our borders. It was a very appealing, very simple idea which went along with take back control of our laws and our money. Immigration control is not done through border control. In fact, we never lost control of our borders. Any of you who've ever come into Stansted or Heathrow or Gatwick, you have to show your passport. There is border control. Immigration control is done largely by employers, and it's done largely by employers through checking people who've got the right to work. It's done by banks, checking people who've got the right to take out open bank accounts. It's done by landlords who have got to check people who've got the right to reside. It's essentially the privatisation of the immigration, and the penalties for employers and landlords if they get it wrong are draconian. So the reality is, going forward, whichever system was put in place, it will be employers who've got to administer and employers who have to pay the price if they get it wrong.
Thank you very, very much. And just one final quick question is this one that you think can be fudged? We talked about a year to go, but could be fudged through this autumn and like be settled for real in the transition period? Or do you think
Yep.
we've
So
got to show our hand before then?
No, during transition, existing rules will apply. The question is what will happen on the 1st of January 2021, and
Do we have to say what will happen in 2021 now, or do you think we can get away with playing it both ways for a bit longer?
There was meant to be an immigration white paper last autumn. It's been kicked into the longer grass. The Migration Advisory Committee, is doing some detailed research. They published an interim report this week. But they're very keen to say, please don't read too much into this report because we haven't... The big political question of whether we give preference to EU nationals going forward has not been decided.
So you might say we don't know what we're doing, but Shanker, can you try and cheer us up? Because we've had a bit of bad news from our last two speakers. Is there still a way with a year to go that it could still work out okay? Trade in particular.
So I'm going to focus on trade policy. And what I'll do is talk about what we need to do going forward. Well, obviously a year to go before we leave the EU. December 2020 is the stated end of the implementation period or transition period, however you want to call it. And so I'm going to talk about what we can do going forwards. Before I do that, I want to make a couple of contextual comments about the global economy and the global trading system. So, then these are important because if these were different, then you would have a different set of solutions that you might propose for this sort of situation. So, the first thing is on the global trading system. As you know, the global trading system is in crisis. We haven't had a conclusion of a global trade round since the Uruguay round in 1995. So 23 years without the conclusion of a global round is a third of the history of the GATT system itself. It's an unprecedented period. And so the global trading system is in trouble. In terms of the things that the UK does well, which is primarily, our strength in services exports. We are the second biggest exporter of services in the world. The progress in terms of services has been very, very slight. So if you go back to 1997 and you project it forward 20 years, you would think, actually, we were in pretty good shape. We just negotiated the Uruguay round. We had negotiated a round on basic telecommunications that covered regulatory issues in the basic telecoms agreement and the reference paper on competition safeguards. This set the path for a lot of the telecom privatizations that occurred in many, many countries, and that's one of the reasons why telecom privatisation tended to work better than other areas of privatisation. That reference paper dealt with internal regulatory issues. It dealt with things like anti-competitive cross-subsidisation. It dealt with interconnection policy. So it dealt with things that were very much regulatory things. We were supposed to then do financial services. We were supposed to then do energy services. And what the WTO had is a built-in agenda on services where countries were supposed to put forward various services for liberalisation over that period. what happened, if you remember the 1999 Seattle Trade Ministerial, where we had the riots in the streets and the collapse of support for the global trading system and for free trade in general, meant that none of these things happened. So we had 21 years now, of virtually no progress in this area. Now, what we've seen in the global economy as a result is a stalling of the global economy, which goes back even further than the financial crisis. So measures of actual wealth creation, things like global industrial output, have been down since before the financial crisis. The Global Trade Alert, which looks at the increase in regulatory protection, has noted that there has been a massive increase in regulatory protection from the financial crisis onwards. So while we didn't embrace pure protectionism and increase tariffs as a result of the financial crisis, we did increase regulatory protection. And all of this has an impact on the global economy, and that's one of the reasons why the global economy is somewhat stalled. The third sort of contextual point is the direction of travel of European regulation. So we've looked at this, and I believe that the direction of travel of European regulation, which if you think about the 1970s and 80s and even the 90s, European regulation was pretty pro-competitive. You had things like the competition rules, you had the state aids rules, you had a lot of things that were essentially pro-competitive. But the direction of travel of European regulation, I would submit, has gone in a more anti-competitive, a more prescriptive rule book direction. So you have these sort of three major contextual points. What does the UK do now? Well, the UK is in a process to be able to execute an independent trade policy. So what does that independent trade policy look like? And what do we need to do between now and the end of the implementation period? So what you need to do is look at, you build your trade policy, and this is not unique to the UK, this is any country would do this. You build your trade policy on four fundamental pillars. The first is what you can do unilaterally in terms of tariff reductions and improving your own domestic regulatory environment. And what is often lost is in the debate is actually that's where a lot of the biggest gains actually come, what you can do yourself. And we're not talking about massive deregulation, we're not talking about becoming Singapore, although I find it quite amusing that Singapore is often used as the example, because actually the regulatory system in Singapore is not entirely free. But what we are talking about is pro-competitive regulation. So we're talking about a regulatory system that enables market competition to work. And actually all the countries in the OECD and WTO have already accepted this as a defining principle. So in the OECD there is a competition assessment and regulatory toolkit, which every OECD member has supported. In fact, the European Union was and its member states were one of the biggest proponents of the competition assessment toolkit in the OECD, which essentially says that we should promulgate regulation in ways that are the least anti-competitive, consistent with your regulatory goal. In the WTO, the general principle is that we promulgate regulation that is least trade restrictive, consistent with the regulatory goal. So these are things that all European member states, including the UK, and other OECD countries have essentially accepted. So that's what we're trying to do. That's where we're trying to get to. We're trying to get to a pro-competitive regulatory system. And for a long time, the European Union, I would submit, was an engine of development in that direction. So these are the sorts of things unilaterally we want to do. The other thing you want to do is look at your tariff system and see what you can reduce. Things, for example, agricultural products that we don't produce, or things that are not directly competitive with things that we do produce. These are ways of getting a win in terms of your overall food price.
And you're assuming out of the customs union?
Well, in order to do those things, you would have to be out of... in order to do those things, you have to have control of your tariff schedules, and you have to have control of your regulatory system. So that means you have to be out of the customs union and out of the single market. Bilateral. Obviously, the EU agreement is massively important, and that is something that we need to be progressing on. Now here, I think there's a couple of things where I would submit that our negotiators need to up their game. the approach has been to be very reactive, to wait for the European Union to put proposals on the table. One of the problems of the EU in trade policy is it takes a long time to get a proposal out of the EU because of its internal structures. But once you have text, once you have a proposal, it's very, very difficult to change it. So if you react, if your approach is to wait and see what the European Union proposes and then to react to it, you're not going to have much wiggle room to make changes. So one of the things we need to do going forward, and we frankly need to do this from right now, is to be much more proactive about putting text on the table. And there's one particular area where we really need to put text on the table, which is the area where you're going to have the biggest problems. And that is, of course, regulatory recognition and the whole regulatory space. So in every trade agreement, there is a regulatory coherence chapter in modern trade agreements that will deal with good regulatory practice and will deal with regulatory recognition. And there's a history in the WTO, in the TBT, the Technical Barriers to Trade Agreement, in the Sanitary and Phytosanitary Agreement, in various other agreements in the WTO. I mentioned the OECD competition assessment and the regulatory toolkit. There's a whole history of things that people have done over the last 70 years in terms of regulatory recognition. And what we are asking the Europeans to do is to go from here. So that if that's the direction of travel, we're asking the EU to be here. But here is not in isolation from the rest of the things that have happened over the last 70 years. So what we are going to have to do is put text on the table, suggest methods of regulatory recognition. It is not true to say, as some have said, that regulatory recognition, mutual recognition, is only about testing. There are underlying product regulations that have been recognised. For example, in the even New Zealand EU meat trade, underlying product regulation is recognised. CETA has provisions. The Canada Agreement has provisions on this as well. But we need to get much more aggressive about putting forward text on the table. So that's the bilateral piece. Then there are other agreements bilaterally you might do with the US, for example, with others, and of course you have the novation of our existing agreements that we have through the European Union. And this is another area where I think there needs to be a change in our approach, which is those sorts of things need to be done bilaterally by the UK. It is in the interest of the European Union, particularly on the novation of trade agreements point, to not let us do that, to want to do that themselves. In fact, that is what they are currently saying. So it's going to require a bit more backbone from our own negotiating team to actually say, no, we actually need to do this bilaterally. And they need to interpret the implementation agreements provisions on the duty of sincere cooperation and common commercial policy in a different way than they have been interpreting it so far.
Can we wrap up fairly soon, just because I know people...
So just two other pillars. One is plurilateral, which is what you do with existing regional platform agreements. So we have suggested that UK accession to the TPP is something that we should be doing. TPP is one of the most liberalising agreements. It's a way of bringing... and the US is likely to go back into the TPP fairly shortly. What's interesting about Donald Trump, without getting into a sidetrack about Donald Trump, is that he tends to say these crazy things with respect to trade policy. I'm just confining myself to trade policy now. And then he'll row back. And you saw this with the 232 action on steel. You'll see this with NAFTA renegotiation. You'll see it with everything that he's doing. And we'll see that with TPP. So I'm certain that the US will be back in TPP before too long. It's a significant agreement, very liberalising. And then finally, the fourth pillar is the WTO. And this is a very, very significant pillar as well. Operating decisively in the WTO, in the implementation period, actually joining some of the groups that, for example, the plurilateral group on e-commerce is a very important group to join. There's a lot of different WTO groups we need to actually be active in. There's a lot of global standard setting organisations we need to be actually active in. And if we are able to do that, then we'll have a better pathway forward. You may have, be following the debate about agricultural import quotas. This is another area where we need to have a bilateral conversation with those major agricultural exporting countries. If we have an agreement, because we've got to be able to say we can offer you liberalisation in the future, and the future is fairly soon. If they don't believe that, then they will seek that extra access right now. It will complicate our WTO position, and it will make it very difficult for us to play that role in the WTO. So all of that requires a change in approach from our negotiating team, and the most fundamental change would be having a single mind over all of the trade negotiations, because you need to read across the different negotiations that you are involved with, because you need to be able to make those trade-offs. And the European Union, in my experience, is a much better negotiator when it knows it's not the only game in town. If they think they're the only game in town, then we will have a very tough time.
Treat them mean, keep them keen. I think we should, if it's all right,
Yes.
just pause now to make sure people can bring in questions. I think we can go through till, I'm just looking at my colleague, we go through to 8, Saskia, can't we? And if that's all right, we'll leave that there and bring in people. Please keep them really crisp so we can give it a go. We'll take 3 or so at once. Okay, chap here at the front, please.
Just talking about the trade policies.
Yep.
Can I just hold it 1 second? Thank you. Nobody will hear you.
Hi, sorry, my name's Chris Key. Regarding the last speaker and innovation of trade deals, Liam Fox was going around the world assuming that we were just going to, change the ink and they'll be re-signed. But I thought that South Korea and Chile have already said, hang on a minute, guys, we're not automatically, we're going to innovate these. Yeah. So 2 big trading partners already, or certainly South Korea, which we have trade deals with through the EU. What does that say about how it's going to go with other countries? Because to me, I'm not very optimistic based on those 2 examples alone.
Right, let's get a couple more because people have been... Yes, please.
I'm not a lawyer, so this might be a silly question. I was interested in listening to your 5 cases. What I wasn't clear about is you mentioned the result would depend on, as I understood it, the interplay between politics and the law. I just wondered, in terms of, if you call something a showstopper, which is something which necessitates a referendum or a general election, are any of those 5 cases what you might call potential showstoppers?
Okay, nice and pithy. We've got, let's take 2, chap with the glasses just there. No.
I can have a question for Ian. How much havoc will the House of Lords wreak to the withdrawal bill?
Very good, very good. Let's scoop up just a couple more while we're here, because everyone's chucking their hands up at once.
Sorry, I've just forgotten the name of who I want to talk about, but I think you'll help me. I'm having one of these brain fades. To go back to the question, important question actually, of...
Keep it short, please.
Of Labour, yes, okay. Of Labour's position, particularly Jeremy's position.
Yeah.
I just wanted to recount the anecdote that on the occasion of International Women's Day, Emily, and I always forget her name... Thornbury said clearly, we must leave first. Of course, we must leave. And it really would have been a journalistic anecdote to recount, but that's it. And the real reason was, over and over again, the referendum. As some kind of duty above everything else. So I'm hoping, and I wonder if Jolyon particularly had some response to this, whether the recent faults in electoral law committed by the Leave campaign might somehow finally dislodge Labour's obsession with sticking to the referendum.
Okay, that's great. And then there's one more person. We'll come into this side of the room in a minute, but we'll just take very quickly, please, these 2 here on this side.
Question for Jolyon Maugham. With the exception of the case being looked at by the Electoral Commission, do all of the other 4 cases ultimately get referred to the ECJ?
Right, nice. Crisp question. And
yeah, just a very quick question on trade deals. Can you maybe give more information around the skills and the actual resourcing to get these trade deals done, basically?
Right, the capacity. Very, very good question. I think we should go first to Ian, who might want to say something about WTO terms, which I know something you've thought about that Shanker was talking about, and then also the questions about politics, like Labour's position, particularly the Lords, how much havoc is it going to reach, and then whether you can just tell anything from the way the EU's handled other cases like South Korea in terms of where we're likely to get to in trade?
I'm definitely going to forget at least one of those. It's true. So I'm going to talk very briefly about WTO and other free trade agreements. I used to have a life and I used to talk about very interesting things, and no longer is that available to me. So I would say this on the free trade agreements. You need a certain amount of capacity. I mean, you wouldn't want to, you can't really do it simultaneously anyway in terms of the stuff that we're doing, because no one's going to really want to come up with a proper deal with you until they've got some assessment of what your relationship is with the single market. And even if they did want to do all of that, we don't really have the negotiating capacity to do it. So it wouldn't be wise. And that's one of the reasons that the only things the EU did give in on the transition was, oh, you can sign the trade deals, which you're never going to get during that period anyway. So clap, clap, you know. When we do come to do those deals eventually, we're basically going to say, it could go another way, but it won't. We're going to say, we're going to open up our agriculture and a bit of our manufacturing in order to secure penetration of our financial services. That is what the arrangement is going to be. That is what the dynamic is going to be. Now, the trouble when you do that is that is a much more politically controversial move than is currently clear. At the moment, everyone thinks that, you know, a deal with the US is very, very wonderful. Everybody wants it. If you remember when the US was doing the deal with the EU, it was all about secret investor courts. Then, you know, that'll still be there. And now suddenly we'll be start talking about the chlorinated chicken and the hormone-injected beef. You take something like chlorinated chicken. It's not actually harmful in and of itself. What it is it is a symptom of a meat process that doesn't give a damn about the welfare of the animal or what goes on before the point. Because it gets to the end point and you say, just wash the damn thing in chicken and we'll get rid of all the filth that we've done up until this moment. Now that's a symptom of what happens when you get very different regulatory structures butt up against each other. Mm-hmm. That is not about a sort of autonomous decision of we're going to do this with our regulation. It is what does our larger trade partner want and what will we therefore do in order to tempt them over. And that will have quite severe repercussions for our domestic things. Very briefly on the Lords, I mean, they're gonna kick that thing around a bit. I would guess that there'll be maybe 10 things that they send back to the Commons, but eventually they'll give in. They get very nervous about generally sending stuff back to the Commons. They're especially nervous with this because, as Jolyon was sort of talking about, you know, the will of the people sort of stuff gives it this additional thing, and of course, you know, the Mail and the Express and all the other numpties are completely up in arms. So they'll go for about 10. They'll send it back. It'll bounce, I think, once. I think it'll ping pong once, and then they'll let it do whatever. However, this is their area. They're good on process. You know, process is the one bit where they do feel like they actually have a spine on. So they will do it, but I wouldn't expect that to be anything that properly holds this kind of thing up.
Thank you very much. Now, Catherine, I wondered if you could just say, as someone who's a lawyer and interested in this interface between politics and the law, do you think, obviously Jolyon's talked about the detail of the cases, and we've already had the Gina Miller case, but could you see one of some sort of technicality, some process, some legal case being the hook on which Brexit could yet unravel or not?
No. I think Jolyon's working hard. If there was a killer case, he would have brought it. What he's trying to do, is to sort of nibble round the edge. And the reality is that the judges are extremely wary about looking at any of these cases for the reason that he gave. That they get, I think, one of the lowest moments for us as lawyers in the last 18 months was to witness the front page of the Daily Mail and the enemies of the people. Now, I'm not saying that judges are perfect and they should be beyond repute, but beyond criticism. But in that case, they were doing their job to the best of their ability, and their job was to interpret our extremely open-textured constitution as to essentially what the constitution requires. And why that front page of the Daily Mail was so shocking to lawyers was it not only cast out on the skills of those individual men, they were 3 men, but the fact is it brought the trust in the judicial system into question. And our judicial system is largely dependent on a high level of trust that the people who are deciding these cases are deciding them as fairly as they can within the framework of the law. And so that front page, it has been incredibly damaging, and it's got longer term implications because it's got implications for the withdrawal bill. One of the areas that might be changed in the Lords, going back to your question, is an area that the Lords and the Commons are actually very sensitive to, which is the clause about how the British courts should take into account future judgments of the European Court of Justice. And the language, I haven't got the text in front of me, but it says they should take into account where it's considered appropriate. I think that's the correct term. And the trouble is it puts tremendous discretion in the hands of the judges. And the moment the judges decide a case, relying, as we all expect them to, particularly in the early days, very heavily on case law of the Court of Justice, if the law in that area is based on EU law and the outcome is one which is unpalatable to the Daily Mail, they will again be pilloried across the page. Now, this is not because judges can't take it. That's not the point I'm making. The point I'm making is the long-term damage it's doing to the reputation of the legal system.
Thank you very much. Jolyon, there are a couple of specific questions to you there, weren't there, about your cases?
So, I mean, I agree with Catherine's analysis. None of these cases, or one of these cases could be a showstopper, but the other four are designed to have political effects in the political sphere, and are basically about, fundamentally about governance, about ensuring that the law as we understand it is upheld. And I would not want a showstopper case because I fundamentally believe that these important decisions about the shape of our society now and in the future should rest with the people. I genuinely believe that. I do not want judges to hold that type of power. And the only case that's an exception to that is the Article 50 case, which would bring Brexit to a shuddering halt if it were to succeed. And I don't find that very democratically palatable. And that's one of many reasons why I'm not involved in that litigation. I also really want to echo Catherine's point about the damage that is done to the rule of law. I wrote a couple of weeks ago about how our constitutional infrastructure, which has served us very, very well because it has never been stressed, is now crumbling for me quite alarmingly. And it's crumbling because government no longer feels bound to adhere to constitutional convention, and because government and the media no longer play by the rules of cricket. There's probably no better way I can put it than that. And so I wrote a piece a couple of weeks ago in which I argued, and it's something I'd thought about for an awfully long time before saying it, that in the Gina Miller case, the Supreme Court was worried. It was worried about the rule of law, and it did not do in that case what it knew that it should have done, and it did not do it because it feared that the rule of law would collapse if it did it. So,
what should it have done?
It should have referred the question of the revocability of Article 50 to the court in Luxembourg. The court in Luxembourg expected that reference. It was not possible to decide that case properly without knowing the answer to the question whether Article 50 could be revoked or not. The divisional court looked over that cliff edge on the Thursday night, said on Monday we're going to walk over it, and then on Monday it was never mentioned again. If you read the transcripts in the Supreme Court walked a long way around it. And they did that because they were afraid of what the reaction would be in the newspapers and on the streets. They were fearful. And so they decided that they would break the law, they would not observe the law, rather than put the rule of law to the test at that critical and highly charged moment. So if you ask yourself the question, what does that really mean? What that really means is that the rule of law is now conditional. It's conditional on the assent of the newspapers. And I genuinely believe that. I'm profoundly alarmed by it. And so when I talk about the propensity of Brexit to deliver slowly, to deliver fascism or something approaching fascism, I really mean it. I'm not sounding alarm bells. Of course, I'm mocked for saying it. I can bear it, I'm thick-skinned. But for me, we are at a profoundly alarming moment, just looking at the world through that one lens of the rule of law.
Thank you very much. Now, Shanker, in particular on the trade thing, you can obviously reply to anything else, keep it brief, please, but on the trade thing and what other deals that the EU's been up to might tell us about what we might get.
Yeah, so just on this question of novation, the South Korea and Chile situations and other countries that we have deals with through the EU. I mean, the way the novation process works is that you go to both the Commission and the UK go to these countries and say, well, you want to continue market access into our markets. If you do, then we're going to have to novate these agreements. We're going to have to make changes to the schedules. With respect to products coming in and rules of origin, we're going to have to essentially accumulate rules of origin, which means that the Korean government or the Korean Customs Agency or the Chilean Customs Agency has to agree that they will treat a product coming from the UK that has parts from EU 27 as accumulated for the purposes of the agreement, and the same with the EU. So a car coming from the EU has to also satisfy those accumulation rules. And that can be done as long as the UK and the EU maintain the same rule of origin provisions in those two agreements. Now, my understanding is that though that is partly legal but partly political. So from the perspective of the other country, if they want to continue access into the UK and the EU 27 markets, they will want that process to go forwards as quickly and easily as possible. In many cases, there are significant the market share of those countries into the UK versus rest of the EU or to the EU 27 market share is quite significant in the UK. So, for example, the CETA case, in the case of Canada, it's about 30% of trade goes to the UK. So that obviously it's in the interest of Canada to make sure this process goes forward well. Now, the political part of this is that if the UK is unable to give clear signals, the biggest and most important signal the UK wants to be able to give is when we talk to the South Koreans or the Chileans, is to say that we can offer further liberalisation in the future. We want to essentially replicate this arrangement, but in the future we can offer further liberalisation. We have to be able to make that statement, because the more that the other country believes that, the more likely they are to get on with the replication so that they can get into that future world. So the more if there is a lack of clarity about that, then that is going to implicate that process. The other issue that will implicate that process is if we're not able to have those conversations bilaterally with those countries. So here there is a difference between the EU's approach and the UK's approach. The EU would like us not to have those conversations bilaterally with those countries. And this is a negotiating position. A good negotiator will ensure that they are not boxed into a situation where they can't have bilateral conversations. So I think those processes will resolve, provided those elements are in place. And then on trade deals and the capacity to do trade deals, I think there was a question about that.
Yeah,
and also sequencing. The average trade deal takes about 28 months to do. That includes all the EU deals that take a very long time because of the EU's baggage and difficulty in doing trade deals. NAFTA was done in 14 months. The US-Australia deal was done in 16 months. They don't have to take a long time. They will take a long time if there isn't political will to do them, and if you have a lot of defensive baggage. In terms of capacity, one of my advisory board now, former trade commissioners in the place I was before, Luis de la Calle, who was Mexico's chief trade negotiator on the NAFTA, describes how Mexico, when they were negotiating the NAFTA, had been out of trade policy for over 100 years and had nobody who could do this. When I first went to the US in the FTAA process, the Free Trade Area of the Americas process, the Mexican negotiators within about 4 years had become so good that other Latin American countries wanted to hire them. So it is possible to develop skills. It's possible to develop the ability to do these things, but you don't learn it in a classroom. You learn it actually by doing, and you learn. And there's no sort of magical negotiator. I mean, you just need to know the subject matter, and you need to know how to negotiate. And knowing how to negotiate means not, checking in with the other side about your negotiating strategy. It means assuming that the other side is on, in fact, the other side of the table. These are things that we have not been, very good at so far. So that does need to change.
Thanks. I mean, it's striking, isn't it? Thinking if you were a 20-odd-year-old civil servant in 1973, when we joined, you'd be in your 60s now, and so Whitehall is learning on the job with this clock ticking. I'll tell you what I'm going to do, which is very unusual for these things, just because I'm going to invite, if there's any final comments or questions for thought. We're not going to have time for another round of comments, but just from this part of the room where people were keen to get in, if anyone's got any short thoughts to leave us in, and then we'll be able to go upstairs and continue the conversation with a glass of wine in our hand. But just 3 quick comments or questions, and then I think I'll call it time.
Could I ask anyone about the National Health Service, and most importantly about the fact that our NHS has one of the world's greatest data sets? What is the interest from the United States particularly, and from this Tory government in wanting to make sure that aspect of artificial intelligence and the data sets is included?
You're going to have to get one of us over drinks to see if we can handle that. One more here, and then a final one at the front, and then we're going to stop.
Am I wrong that my fear for Labour is that if they become realistic, then they might take a bad deal? If they stay unrealistic in their tests and they demand the high grade impossible, then they will vote against. Is that the wrong way to be thinking of things?
Seems that wouldn't be out of kilter with the upside down way of politics at the moment. And then finally, chap at the front here, and then I'm going to call it time.
You said that it would take maybe 12, 14 months to negotiate these trade deals, but the EU-Canada trade, the CETA, took about 7 years to negotiate. So why are you so optimistic about the length of time?
More scepticism, more doubts, it has to be said. But let's leave things there. Thanks very much for coming along and for chipping in those ways. Lots of good food for thought.